QSA207 Construction Law 2, Breach of Contract and Remedies of Contract. These notes are intended for educational purpose only, as well as to give basic understanding on principle in construction contract. Any details, please free to refer anyone who are expert in this area, or do extra homework by referring to the books related to the principle in construction contract. At the end of the series, students should be able to demonstrate the principle in construction contract in construction related to quantity surveying practice. Breaches of contract. Breach of contract occurs when a party fails to perform some primary obligation under the contract and the ordinary remedy is an action for damages. The plaintiff must prove the existence of the contract, the relevant obligation in the contract, its breach, that breach caused loss and or damage which is too remote, and that he is entitled to recover damages measured at the appropriate rate. There are two possible consequences of breach. The first one is condition, where innocent party may rescind the contract, discharge himself from the contract, and refuses performance by the other party, or rescind the contract and claim damages, or continue with the contract and claim damages. Secondly is warranty, where the party can claim damages only. The objective for award of damages is to place the innocent party, so far as money can do it, in the same position as he would have been if the contract been performed. The distinction between collateral warranty and a collateral contract. The first one is a collateral warranty is merely a term of contract, the breach of which only entitles the party to sue for damages and doesn't give the party the right to repudiate the contract. The second is a collateral contract is a contract by itself. However, the breach of collateral contract only gives rise to an action for damages for breach thereof and not a right to repudiate the main contract. Partial performance. The general rule is that a party must perform precisely what he contracted to do, and a party who has only partially performed his obligations cannot recover any payment. However, there are exceptions to this rule. If the party performing the work has substantially performed his obligations, then he can recover the contract sum less the cost of remedying defect or the value of omissions. This doctrine applies to faulty performance rather than an incomplete performance, and if failed part relates to a condition, then it cannot be claimed. Okay, so this is the sample case in Hennig versus Isaac 1952. So the next video will illustrate this situation.
Ever wondered what happens when a contract goes awry due to faulty design and poor workmanship? Well, buckle up as we dive into the fascinating world of contract law and disputes. Once upon a time, in the bustling concrete jungle, a decorator, we'll call him P, entered into a lump sum contract with a flat owner, let's name him D. The deal was simple. P was to decorate D's flat for a total of £750, which would be paid as the work progressed. As P started his work, D was filled with anticipation, keen to see his flat transform into a haven of design and style. But as the work unfolded, his excitement turned into disappointment. D found the design faulty and the workmanship poor. He refused to pay the balance of the completed work, citing these issues. Now, this is where the plot thickens. P, having invested his time and resources into the job, was understandably upset. He believed he had done substantial work and therefore was entitled to his payment. The dispute was unavoidable, and the matter was brought before the court. Following the principles of contract law, the court had to weigh in on whether P had indeed made substantial performance and was therefore able to recover his payment. They had to determine if D was justified in withholding payment due to the defects in the design and workmanship. After much deliberation, the court held that P had indeed made a substantial performance. The defects did not nullify the entire contract. Therefore, P was able to recover his £750. However, D was not left high and dry either. The cost of putting right the defects, which came up to £56, was deducted from P's payment. To summarize, the court found a middle ground where both parties had to bear some responsibility. P, who had performed a substantial part of the contract, was entitled to his payment. However, he had to bear the cost of repairing the defects in his work. On the other hand, D, who had initially refused to pay, was required to fulfill his contractual obligation, but he was spared the cost of fixing the defects. In the grand scheme of things, this case teaches us about the principle of substantial performance in contract law and how defects in workmanship do not necessarily void a contract. It's a testament to the nuanced and balanced nature of contract law, where each party's rights and obligations are carefully weighed and considered. So the next time you enter into a contract, remember the tale of P and D. It might just save you a lot of headaches down the line.
Frustration. Under Section 57(2) and 3 of Contract Act 1950, the law may treat the contract as terminated under the doctrine of frustration if some event occur during the currency of the contract without the fault of either party, which makes further performance impossible or illegal, for example, war, which makes it something radically different from what was originally undertaken. Under this doctrine, the parties are freed from any further obligations under the contract. Note that it doesn't render the contract void from the beginning. Money paid before frustration is recoverable, and money payable ceases to be payable. Interference by the government may frustrate a contract. So the following video in next slide will demonstrate the case of Metropolitan Water Board versus Dicker 1918.
Have you ever pondered the nature of contracts? What happens when an unexpected interruption throws everything off course? Welcome to a riveting exploration of the case of Kerr and the Water Board, a story of contracts, war, and the doctrine of frustration. The adventure begins in the early stages of a 6-year contract. Kerr had agreed to construct a reservoir for the Water Board. It was a straightforward arrangement. Kerr would build, the Water Board would wait, and at the end of 6 years, there would be a reservoir. However, after just 2 years into the contract, the winds of change began to blow. A wartime statute came into play, commanding Kerr to cease all work on the contract. This was not a minor hiccup, but a major disruption. The simple contract to build a reservoir was suddenly, and quite unexpectedly, put on hold. Despite this, the Water Board held firm. They argued that the reservoir contract was still valid, that it was still in effect. They believed that the contract should be completed, albeit with an appropriate extension of time. But was this a reasonable expectation? Could the contract simply be resumed after such a significant interruption? The court had to examine these questions, and their conclusion was fascinating. The court held that the contract was frustrated. Now, in legal terms, frustration is a doctrine that can be applied when a contract becomes impossible to perform due to circumstances beyond the control of the parties involved. In this case, the interruption was not just a delay, but a transformation. If the contract was resumed, it would be a different contract. The nature, the essence of the original agreement had been fundamentally altered. Thus, the doctrine of frustration was applied. To recap, the case of Kerr and the Water Board presents a compelling exploration of the nature of contracts and the impact of unexpected interruptions. It highlights the role of the doctrine of frustration in contract law, demonstrating how a contract can be deemed frustrated when a significant interruption transforms its very nature. This case serves as a reminder that contracts, while seemingly straightforward, can become complex in the face of unexpected circumstances. It underscores the importance of adaptability, both in contract creation and execution, and the critical role of the courts in interpreting and adjudicating these complexities. So the next time you consider the nature of contracts, remember Kerr and the Water Board. Remember that contracts are not just about agreements, but about navigating the unexpected. And remember that when the unexpected does occur, the doctrine of frustration is there to ensure fairness and justice. Thank you for joining this exploration. Until the next time, keep questioning, keep exploring, and keep seeking justice in all its forms.
Next, let's look on remedies of contract. There are several remedies available for breach of contract, including damages, quantum equitable remedies, which is specific performance, injunctions, rescission, and rectification. For assessment of damages, damages are intended to restore to the plaintiff the benefits or profits which he would have earned if the contract had been performed, and compensating him for the expenses caused by the breach. For example, if the contractor fails to complete the works, then the measure of damages will be the cost of completing the project in a reasonable manner, less the contract price. Under Section 7 of the Contract Act, the injured party is entitled to damages arising naturally out of the breach, or damages which, because of special knowledge, special damages at the time of making the contract, which would have been in contemplation of both parties as the probable result of the breach, but damages cannot be recovered for losses that are too remote. Under the rule in Hadley v. Bazendale, 1854, damages may only be awarded in respect of loss that arises naturally from the breach, loss that which may reasonably be supported to have been in the minds of the parties at the time they entered into the contract. The principles to be adopted in the assessment of damages are illustrated in the following cases of Hadley v. Bazendale, 1854.
Have you ever pondered how crucial time can be in business operations? The world of law is no stranger to this concept. Every minute wasted can mean lost profits, as seen in a case involving a pair of mill owners and a critical delay in transit. This tale begins with the mill owners, who we'll refer to as P, reaching out to a carrier, henceforth known as D, to transport a broken crankshaft to its makers in Greenwich. This crankshaft was not a mere piece of machinery. It was the heart of the mill, the very engine that kept the operations running smoothly. However, a series of unfortunate events led to a delay in the transit. The mill owners, left with an idle mill and diminishing profits, decided to claim their loss. They reasoned that the delay in the transportation of the broken shaft had directly resulted in their mill being out of action and consequently their loss of profit. The essence of their claim hinged on the notion that the delay was not a natural consequence of the transportation of a broken shaft, and the defendant, D, did not know that the mill would be idle until the new shaft was delivered. However, there was a twist in the tale. The court held that the claim must fail. The reason was twofold. Firstly, the defendant did not know that the mill would be idle until the new shaft was delivered. This meant that Part 2 of the rule did not apply. Secondly, it was not a natural consequence of delay in transport of a broken shaft that the mill would be out of action. This meant that Part 1 of the rule did not apply. The court also highlighted that the importance of the shaft was not apparent. There could have been a spare shaft, which would have allowed the mill to continue operations. The mill owners did not provide any evidence to suggest that they had no spare shafts. This case underscores several key points. Firstly, It emphasizes the importance of communication in business. Had the mill owners informed the carrier about the importance of the crankshaft and the potential consequences of a delay, the outcome might have been different. Secondly, it highlights the importance of contingency planning in business operations. Having a spare shaft could have prevented the mill from being idle and saved the mill owners from their loss. Lastly, it underscores the importance of time in business operations. Every minute counts. As seen in this case, a delay in transit can lead to significant losses. So, the next time you find yourself in a situation where time is of the essence, remember the tale of the mill owners and their idle mill. Consider the potential consequences of delay and plan accordingly. A little foresight and planning can save you from a lot of trouble down the line.
The measure of damages. Damages are awarded in order to place the injured party in the same position as if the contract had been performed so far as possible. There are two ways of doing that. Award the difference in value or award the cost of restoration or reinstatement. Awarding the difference in value is appropriate where the subject of the dispute is commonly available, the defective item can be sold and a replacement bought. Awarding the cost of restoration is appropriate where the defective item is unique or cannot be replaced. If the conditions are such that both types of award can be used, the cheaper solution is adopted. The pre-assessed amount of compensation payable is called liquidated damages. Occurrence of the breach gives the right to claim the liquidated damages, and the plaintiff will not recover more than that sum, which no action for unliquidated damages will be allowed. The sum constitutes the amount that the plaintiff may claim without having to prove the damage. Liquidated damages, which must be quantified in money terms, are usually included in construction contracts. Such amount must be genuine, pre-estimate but not necessarily accurate estimate, made at the time of executing the contract of the loss a party would suffer due to a breach by the other. With such provision, the parties know from the start the risk they bear and also save time and money on arbitration or litigation. Quantum merit means as much as deserved or what the job is worth. It is a claim for a reasonable sum in respect of unremunerated services that have been executed. It may be used as a means of obtaining payment under a contract where no remuneration has been agreed. In construction, quantum merit may be claimed where an employer has broken the contract. Quantum merit generally is used in damage claim when the contractor doesn't have a written agreement to perform the work and the other party has been unjustly enriched by work performed. The difference between a claim for damages and claim in quantum merit is that the former is a claim for compensation for a loss, the latter is a claim for reasonable remuneration. Each is a claim for undetermined amount, situation in which quantum merit claims may apply, where work has been done under a contract without any express agreement as to price, where there is an express agreement to pay a reasonable price or a reasonable sum, where work is done under a contract which both parties believe to be valid at the time but which is in fact void. And lastly, where work is done at the request of one party but without an express contract. For example, work done pursuant to a letter of intent. Therefore, in deciding appropriate sums, the court have considered market rates for similar work in the case of Lesabor versus Morrison Briggs, 1993, prices determined via contract negotiation in the case of Way versus Latila, 1937, and prices operated in analogous contract, Bank Paribas versus Venegas, 1994. Next, let's look on the equitable remedies. Specific performance and injunction are termed specific relief and is found under Section 4B and 4C of the Specific Relief Act 1950. Injunction is the court ordering prevention of action, and it is often applied in the tort of nuisance. Specific performance is the court ordering a party to carry out his contractual promises. Rescission is the court setting aside a contract and restoring the parties to their positions before the contract was entered. Rectification is the equitable remedy where, through mutual mistake, a prior agreement has been reproduced incorrectly and incorporated into a contract. Rectification seeks to rectify the contract to incorporate the correct prior agreement. For Q&A session, if you have any question, you may ask in the WhatsApp group. This is a class exercise based on this topic. That's all for this topic. Thank you.